And we are live.
Good morning. This is Senate Judiciary. We're taking up H-121. And John Gray is the first witness, and I'll let Senator Sheem take over the committee.
Sounds good. Hey, John.
Morning, everyone. John Gray, Legislative Counsel. How are you? It's only Wednesday somehow. So 121. I'm not sure exactly what document we are looking at, but given that we are talking about the private right of action on the Senate side, I'm assuming that we are thinking about the Senate Health and Welfare proposed amendment.
Yes.
We're looking at draft 3.1, dated 5/5/3:23 p.m.
Okay. So it's interesting. I have 4.1, but I can still reference it. Should be the same content.
Ben, that other bill is H-233. H-233.
Thank you.
Do we have this up on the committee page? I'm sorry, I'm just running from other.
Should be. Yes, I uploaded it. This is what we received from the Alliance.
Okay.
John, you want 3.1?
Oh, that's super helpful. Thank you. Yes, I have a 4.1, which is slightly different. So thank you. Yes, so we are talking about the private right of action that Senate Health and Welfare is considering adding to the data privacy bill. And the specific PRA is starting on page 16. And to talk about what this does here in the Consumer Fraud Protection Statute, so in Title IX, as I'm sure you guys are familiar, there is already an underlying private right of action available for violations of consumer fraud statutes. That's this call out that you see in subsection A. So when we say a person who violates this chapter or rules adopted pursuant to this chapter commits an unfair and deceptive act in commerce in violation of section 2453, what we're doing in calling that out is linking this to the Consumer Fraud Protection Statutes, which has in section 2461, subsection B, it's actually titled civil penalty, but there's a underlying private right of action there. So this is what this subsection A does. But there's the second clause to this sentence, which slightly modifies this to restrict the availability of that underlying private right of action. So we say, yes, this is linking in section 2453. We're bringing in Title IX, but the Attorney General shall have exclusive authority to enforce such violations, except as provided in subsection C. So I can jump down to subsection C, and that's on the bottom of page 17. It states that a private right of action available to a consumer for violations of this chapter or rules adopted pursuant to this chapter shall be exclusively as provided under this subsection. And then in subdivision 2, at the top of page 18, we have a narrowed approach here to a private right of action. We say that a consumer who is harmed by a violation of subdivision 2419B2, and I'm going to come back and explain what these violations are, but just to get through the sentence, a consumer who is harmed by these two particular sections of the Vermont Data Privacy Act may bring an action under that 2461B, so that's the underlying private right that's already in statute for the violation. But the right available under this subsection shall not be available for violation of any other provision. So what this is meant to do is cabin the availability of the underlying private right of action to two particular kinds of harms. So 2419B2, this is a harm that arises from processing sensitive data without consumer consent. So that would be things like biometric data, so facial templates or hand mapping, data of a known minor or child, consumer health data, which is one of the big reasons this motivated Health and Welfare to look at this piece. So if that kind of data is processed without consent, that would constitute a violation, and the underlying Title IX private right of action would be available for that violation. There could also be a violation of section 2426.
Before you go on to that, can you provide for me the definition of biometric and processing? So I mean,
Sure.
if somebody
Yes.
is just seen on a closed
Absolutely.
circuit TV.
Absolutely.
Okay.
And what I'm going to read to you in 3.1 is going to be slightly tweaked in what you're likely to see, but to call out biometric data is information generated from technological processing of the unique physical or physiological characteristics of an individual that is linkable to them. So this is things like iris or retina scans, fingerprints, vein patterns, data that's used to identify a particular person. It is worth noting that in the 3.1 that you're looking at, there is a call out to depictions, images, descriptions, or recordings, which is quite a broad concept, and data derived from those images, descriptions, or recordings to the extent that it would be reasonably possible to identify a specific individual. I think that this G and H is going to end up changing, and if you would like me to...
G and H?
Sorry, these particular... I'm sorry, I'm assuming a lot of knowledge of this bill. That's totally unfair. Those particular depictions, descriptions, and recordings, and the data derived from those, you're going to see a slight tweak that basically says audio, video recordings, and images descriptions are not going to be included, but what would be included as biometric data is data derived from those images and recordings to the extent that it's used to identify a particular person. So the idea there is images are not going to just writ large, images aren't going to be a kind of biometric data that requires consent for processing. But if people are drawing things like facial templates and the like from them, that kind of classic biometric information, which is your biological information that's being used to track you, would be picked up. So that's what biometric data is. I think you had a second question as well.
Yeah, the processing aspect of it. Yeah, I'm curious, somebody shows up in an emergency room, they're providing data about their, biometric data. But there's, I mean, given the circumstances, for why they're in the emergency room, that they don't really have time to go through any sort of consent process.
Certainly.
Does that create liability for the hospital?
So a couple of answers here. First, processing is a very broad concept. So you're correct. It's basically doing any kind of operation to data. So that includes collection, storage, transfer. It's super broad, what's captured by this concept. But to answer the specific question about what kind of implication would this have for hospitals, this proposed exemption is offering, when Senate Economic Development passed out this bill, they included a data level exemption for protected health information that hospitals, so they're a kind of covered entity under HIPAA. There's a data level exemption for protected health information that's processed by those folks. What this amendment from Health and Welfare goes even further to do is to offer an entity level exemption to hospitals and the like. So they're offering an entity level exemption for covered entities, that is, folks who are subject to HIPAA, hybrid entities, which are, we don't have to go into so much detail about this, but the idea behind that exemption is you're offering a straight, direct entity level exemption. So a hospital in that situation is not going to have to worry about processing. They fit cleanly into that exemption, so they don't need to ask themselves those questions.
What is the...
Yes.
I'm sorry. I didn't mean to interrupt. I thought you were done.
Please go. Yep.
What is the difference, or what is the standard for the private right of action? Is it a negligence? Is it gross negligence? Is it reckless? What is the standard?
So I think it's just beyond a reason. Sorry, not beyond a reasonable doubt. I think it's just preponderance of evidence. But we do have the AG's office here, who has more experience with working with the underlying.
Well, I'll ask that question.
Yeah.
Thank you, John. I'll ask that question of the AG. But I'll express my concern about this piece of the bill, and that is that we have a private right of action. We have all kinds of abilities, and this has not been vetted fully by anyone. We haven't heard we won't have time to fully vet this proposal, nor the proposal in 233. So I'm really concerned about that from the beginning. But secondarily, I've talked to a few trial lawyers and their representatives, and their concern is that this will result in a great deal of trolling from other states where you have these law firms that we see, have a problem, call us. I went through a problem with a snowshoe company in Bennington, where they were almost put out of business, or pretty much put out of business, by some Florida law firm who found that they didn't expressly put into their ads some little things for the blind, the Braille, and these cases. I'm really worried about these lawyers who are just looking for cases, trolling. I guess it's called trolling.
Sure.
Not so much our attorneys in Vermont.
Yep, so a few responses that may be helpful, but I agree this is a much bigger conversation. So one is the reason that Senate Health and Welfare landed on using the underlying consumer fraud statutes for this private right of action is that the proposed private right of action that had been received from the House and that was being considered included statutory damages. So that would be the availability of the greater of 1,000 or actual damages. So folks seeking, it'd be much more readily available for them to go to court and receive a set amount, and they would know that it would be worth it for them to actually pursue that action. The underlying private right of action does not contemplate statutory damages, it's actual damages. So they would need to actually prove specific harms in these cases. The other pieces I would say that are responsive to this are, I think this gets into the question of what sorts of entities are exempt under the Act, which is a big list of things. And so the one question there is that if you think you have exempted sufficiently the folks that you're trying to facilitate providing businesses and services in the state, then I think it's a less meaningful question whether or not there are so-called trolls engaging in this kind of action, because you're trying to protect particular businesses that Vermont deems to be valuable, and then saying, for those outside of the scope, we do want to, in fact, enforce the rights of consumers. And this is, I guess, the third response to it, which is there's talk of litigation in other states, trolls coming to the state and the like. I don't want to feed into any fear mongering or also push back on the fact that that may empirically be the case, but I would say there are reasons to do private rights of action, and one of the beliefs behind it is that lawyers do provide a useful service. What they do is they allow people to enforce their consumer rights, and that's what having folks come in, lawyers making money off of particular pieces, does. It provides a financial incentive for a professional to come in and help someone enforce their rights under this act. So I don't want to push back too much. It may be empirically the case that there are lawyers out there who do engage in this kind of business, but I want to remind people that there's a reason we have lawyers enforce these particular pieces. It's because it does allow consumers to, in fact, protect their rights.
Thank you.
Did you have I think maybe?
Nope.
Okay.
Carry on. Thank you.
So I think the piece, just to return to with the private right of action on 18, is that we're talking about two different sets of harms that trigger this. So this is not broadly all kinds of harms under the Act. It's specific to these two call-outs. So it's meant to be narrow. It's tied to that actual damages underlying statute, so it doesn't provide statutory damages. And I think I didn't get to the piece of addressing what section 2426 is, which is the second violation that would make a private right of action available under this proposed language. Section 2426 is a small section that ends the Act that relates specifically to consumer health data, which is personal data that's used to identify physical condition or diagnosis of a particular individual. And what that section does is it prohibits things like geofencing, so establishing a virtual boundary around healthcare facilities to track or collect information from folks who are entering those facilities. So it's meant to protect people who are going to heightened sensitivity facilities from being tracked. That's the idea behind that prohibition. There's another set of restrictions in that section that relate to ensuring that there's confidentiality if any business is providing consumer health data to an employee. It's just ensuring that that remains under duty of confidentiality, requiring contracts in place to ensure that that duty of confidentiality is maintained, and then prohibiting the sale of consumer health data. So this private right of action would additionally be available for violations of those sections. So if someone was selling consumer health data without consent, that would constitute a violation, and the private right of action would be available. If someone established that geofence to track someone entering healthcare facilities, that would be a violation that would trigger this private right of action. But otherwise, the private right of action is not broadly available for violations of the Act. It's these two particular pieces, and I will pause there.
Senator Sears, not seeing any questions in the room. Senator Rom Hinsdale just walked in, and I think she's on the list to testify as well.
Okay.
Do you have anything else?
I think I've set up the picture at the very least, and I'll remain here. Yep.
Yeah.
Okay, great. Thanks. I don't even know if we're gonna get a quorum.
Oh, wait,
Or do you want to?
Attorney General, do you have, are you on a rush schedule?
No.
Do you mind?
Okay,
Yeah.
great. Okay. Good morning. Good morning, Senator Sears.
Morning.
So I heard the tail end of that, and I think our committee's position overall would be that including sensitive data in a private right of action essentially reopens almost all entities in the state to litigation under the PRA. It includes biometric data, and that is exactly what we are studying in Illinois. So I brought 3 different articles from the Illinois context. Okay, so there are 3 articles that are together, and then you can, you know, the next L shape on the other direction is for the next person. But Illinois is essentially, after about a decade of BIPA, its Biometric Information Privacy Act, set to, as I would understand it, get rid of class action lawsuits because they have had what the Supreme Court, they're called, an annihilating effect on entities that have been taken to court. And that is because it has been per violation. So if they have 100 employees and, you know, 100 employees got misinformed or were seen to have been misinformed about how their image was used for an ID card or their fingerprints were used, then that could shut down a business, a healthcare organization, a nursing home, a school district. I mean, you know, what we have seen is that the biometric data piece can apply broadly across any nonprofit healthcare organization or business. This bill doesn't separate those out. So putting them all under a private right of action can have a really big impact. What you'll also see in there is that a lot of the back and forth has led to different types of workers being exempted from the private right of action, healthcare workers, most recently, I think last year. And that's why the Supreme Court has basically said, we're actually making policy now and we're asking the legislature to finally fix this. That is happening as we speak in the Illinois legislature. So, you know, what our bill has originally is a study led by the Agency of Digital Services in consultation with the Attorney General to come back next year and give us a much better sense with experts at the table, with stakeholders at the table, of what a right-sized private right of action would look like. I bring up Illinois because if we include this private right of action, we would be the only other state except Illinois to have it in place. Washington State has a private right of action just for healthcare information, and I'm happy to work with Senator Lyons next year on that piece. But sensitive data is almost everything back under consideration: biometric data, financial data. You know, so I would say that it's much broader than what you've just heard, and gives me great concern where it is a compromise with a lot of the folks who are worried about the PRA to actually study it and come back next year and get it right. I would also point out that we've had the data broker law in place that this builds on top of for 5 years. It's been heralded as something that's been copied in other states so that we register people who buy and sell data. They you know, now have to be more conscious of deleting people's information per our inclusion of the California Delete Act in this bill. But that has never had a private right of action in the last 5 years. It gave sole authority over enforcement to the Attorney General. So we just copied that language to harmonize the two. You know, our committee looks a lot at private right of action as it relates to consumer protection. And everywhere it shows up, it looks slightly different. It's different for robocalls versus propane versus, you know, data brokering versus now this. And we should take it seriously in each instance. You know, as I mentioned to Senator Sears yesterday, there's a new PRA provision showing up in a pharmacy bill that finance has, and it's not even tied to the Consumer Protection Act. It's just pharmacies now have the right to take someone to court if they feel there's some kind of inappropriate behavior happening per the pharmacy benefit managers but I will send this to Senator Sears if he wants to send it to the committee. Someone from the pharmacy community emailed me last night to say, we were basically shut out of the consumer portal to file a complaint about pharmacist activity about pharmacy benefit managers. And since we're not consumers, and so we were given the private right of action as our remedy. I don't know that that's the only remedy the legislature can come up with for making sure that pharmacists and pharmacies can report concerning behavior. So really, it just is thrown in there, and it was, and as it was explained to me by the Pharmacy Association, that is, I think, defunct now, is what he said, because they don't have enough pharmacists involved, is that that they were told this is the way to get a remedy. I just question that, and I think Senate Judiciary should start to question this culture of leaning on a private right of action, which is generally costly litigation that drives up the price of consumer goods and healthcare costs, et cetera, as instead of smart, responsible policy that lets people actually find an appropriate remedy through our, policy paths or our consumer protection portals and things like that.
Just a quick question for you. It kind of feels like there's a fast-moving and tangled web of where everything is. So
yeah.
Is the recommendation that you're making that your underlying bill is what should move forward, and you disagree with the amendment proposed by?
That's a great question. I think we're all having issues finding each other this morning. So I think Senator Lyons has a quorum issue in health and welfare. I haven't been able to talk to her. What I want to tell her, and I'm sorry, Senator Lyons, you're not hearing it first, is, and she hasn't been before our committee, which is the only committee that has possession of the bill, but we agree with her entity level exemption. There's two parts to her amendment. One is an entity level exemption for essentially healthcare organizations that fall under HIPAA regulation. So we put that in our new amendment. We have an amendment that will hit the floor that incorporates our unanimously passed kids code into our bill. So that can move this year with our data privacy bill, and most of the language there harmonizes those two bills, except it also takes Senator Lyons' first provision about the kind of exemption she felt health and welfare related organizations under her jurisdiction needed, and it leaves out the private right of action.
And that applies to, sorry,
Go ahead.
a very quick question. That applies to 2426, right? The violation for.
I am terrible with numbers, even of the bills.
Yeah, I'm not even sure either. So
You're talking about what does the proposed private right of action apply to from Senate Health and Welfare?
yes.
It's 2426, which is the consumer health data
Yeah.
section, and 2419 B2. Yep.
Okay. And so the amendment that you're proposing applies to both of those,
So the amendment that we're proposing is built into her bill, so I think John would know better what.
Yeah, so this proposed amendment that we're going to be discussing in like 5 minutes will not have a private right of action in it for the Data Privacy Act, so no section call-outs necessary.
But it'll have the entity level
It
exemption.
will have the entity, so what it's taking from the health and welfare proposed amendment is the entity level exemptions, the proposed healthcare changes for that piece, but the private right of action would not be included in this. So I think you're understanding that Senator Ron Hinsdale is saying to go with this proposed amendment and not. Yes.
Okay, thank you.
I would just,
Sorry, Senator Sears.
I would just comment that I appreciate Senator Ron Hinsdale's cautious approach, and I would plan to take the same approach and look forward to the report rather than passing. So I would personally support the Economic Development Committee's proposal. And I think having us as the only state in the union besides Illinois with this type of law does need further study. We've got, maybe 2 days left of our committee meetings, and I don't think we have time enough to get into all these private right of actions that are being contemplated on different bills. And maybe whatever the Finance Committee is considering could also be added to the report. On the pharmacy benefit manager, H233, I believe.
Right.
So I guess I appreciate the need for, or desire for cautiousness, but I also, particularly with sensitive healthcare information, I'm just really cognizant that the world we live in right now, the stakes are high. And so without a private right of action, what recourse does someone have if their information is shared in a way that does them harm?
Well, I think it's important to sort of take that in the context of the details of the bill, because HIPAA, anything under HIPAA was already exempt. It is under a different regulatory regime. So did you have a specific
I mean,
concern?
I think the thing that comes to mind particularly is things like menstrual tracking apps.
Mm-hmm.
And the ways those could theoretically be leaked into, if I maybe traveled to Vermont to seek an abortion, and
Yes.
that information is then given to the state that I came
Yes.
from, where that is illegal.
So remember, and I said this in Senate Health and Welfare, it depends on who you have the private right of action against. And so this bill, if it had the private right of action in, would apply to healthcare organizations and Planned Parenthood, and it would not apply to the government of Texas or the law enforcement that's trying to track you. So if they ask for that information from our healthcare organizations have their own regime under which they would or would not respond. But Planned Parenthood's more likely to be sued under that scenario than the government of Texas.
If the government of Texas asks Apple for the information from the app,
Mm-hmm.
that's not protected under HIPAA.
I don't know how Apple would have that information.
Well, because I put it into the app that they made.
They don't track that information, and that is still protected under the bill. And the Attorney General would have the enforcement authority. I think that would be considered pretty egregious if one or more people somehow through Apple, which is just challenging sort of in the current way it would be set up. But if Apple gave them your location information, your menstrual information, if they had it, the Attorney General would have the ability to go after Apple.
But I wouldn't, even though it was my information, without a private right of action.
I mean, I would say not until next year, but if you look at Illinois, no one's brought down Apple. No one's brought down big tech. I mean, what's been brought down are nursing homes and small manufacturers. There's a lot of low-hanging fruit here, and it's not Apple. So, we have the kids code, which says you can't buy or sell children's data, period. That's stronger than what the House passed in the kids code. And that applies to big tech. The House is now looking at a proposal where they might just apply the PRA to big tech, but I still have concerns about how that would apply, because that would help Amazon and hurt small businesses that do targeted advertising. Some of those other large big tech entities that help small businesses could geofence out Vermont, essentially. So the other thing I've said to various committees and folks is I'm not as worried about who has been here to talk to us about the PRA. I'm worried about who hasn't. Our small business clinics, our folks who work with small businesses the most and our nonprofits. I have a letter from the nonprofit folks asking that we take out the PRA, because that's all of our nonprofits in the state. They all can't be here to tell us, what if we do this? What if we do that? I mean, I can't even tell you how much we've heard. Every time I turned a corner in the building, it was, we use geolocation on kids to make sure that they're safe in the woods when they go skiing. We use IDs to make sure that the people who are at our resort, are who they say they are, and people aren't just crawling all over our mountain to ski without having purchased a pass. We have a lot of businesses that would be impacted. Illinois has not brought down Apple. Illinois has not brought down any big tech. So to me, it feels like we're treating the PRA like it's the master of the universe versus a boogeyman. I'm not doing either. I'm saying we have to get it right. And Illinois is taking a second look because it's had such a heavy impact on their healthcare organizations that we would actually probably be impacting our hospitals or Planned Parenthood more under your scenario than we would Apple.
If I could just interject real quick, I just want to make sure we have time, equal amount of time for the
Yes.
Attorney General.
Yeah.
So if there's no other questions, we could move on if that's good for you.
That works.
Okay.
I'm a free agent since my committee can't meet,
Oh,
so
okay.
I will stay and listen.
Wasn't sure if you were
Thank
in a rush or anything. Thank
No,
you.
no, but thank you, and happy to answer more questions, and really look forward to working with you and Senator Sears on a right-sized PRA in a number of instances as it's being considered as a tool for, I think, a lot of things where litigation isn't always the answer and often harms people that we don't intend to harm.
Thank you.
Do you guys mind if I step out and I can come back to you? Okay.
Good morning.
Good morning. Charity Clark, Attorney General. I thought it would be helpful to begin by providing some just sort of fundamental education on systems of enforcement. So an example that might be more familiar to this committee, if someone is killed, the Attorney General or the state's attorney can bring a charge against them in criminal court. It's a criminal enforcement, but that individual family would have a right to bring a wrongful death suit in civil court. So that's the approach that our system has decided to take in that example. And there are lots of examples like that. And one such example is the Consumer Protection Act, which was passed in 1967. And the legislature, when it passed, decided we're going to have an enforcement by the Attorney General on behalf of the state. And we're going to have the ability for individuals to bring their own claim when they are harmed. And the claim needs to be for their actual damages or injunctive relief. So what that looks like in the consumer context is I buy a boiler, it's $5,000. I install it, it never works. I go back to the person who sold it to me, the company who sold it to me, and I say, you need to give me my money back, this never worked. And they say no. I can sue them and say, here's the bill, $5,000, you owe me $5,000. And that's how the private right of action works in that context, where it's actual damages that you have to demonstrate. This is obviously been in statute longer than probably most of the people in this room have been alive. So it's very plain vanilla. It's all over the Consumer Protection Act. We're very familiar with it. Despite that fact, it's very rarely used. We did a search, and since the inception of the Consumer Protection Act, we're estimating 1 or 2 cases a year are filed using this. The Consumer Protection Act, as you know, is very, maybe you don't know, it's very broad. So it covers unfair and deceptive acts in commerce. So it's very, very broad, but despite that broadness, it's rarely used. So wanted to pass that information on, and also say that in this context, we have been advocating for this bill for many years, specifically related to biometric information that is based on a company. Our information and passion for this topic in my office originated with our investigation into a company called Clearview AI, which screen scrapes the internet of photographs, uses a very impressive and high-tech, effective algorithm to face map the photograph, and then is like basically a facial recognition software that's used. When it started, it was the story that of its inception was broken by a New York Times reporter named Kashmir Hill, who has since written a book about this company, and they are doing something that we feel is unethical and is frankly disturbing. They have now compiled 40 billion photographs and basically have several photographs for every person on Earth. And so a lot of our knowledge and passion for the topic on biometric data comes from our knowledge of Clearview AI. I would encourage you to look into some of the articles and podcasts that Kashmir Hill has written. Early on, it was pretty disturbing. When she broke the story, part of her work was that she wanted to find herself in the app in Clearview. So she brought her photograph to a sheriff's deputy she was interviewing for her story and said, can you find me? And I'm just curious. And so he searched and he said, this is so weird. You're not in the database. I've never found someone who isn't. And that's really weird because you're a New York Times reporter and your face is like around. And then he got a call from Clearview AI saying, why are you looking for Kashmir Hill? So that's the kind of entity. And there's no guardrails other than the Consumer Protection Act that explicitly says you can't do X, Y, Z. It's just you can't have unfair and deceptive acts in practice in commerce. So that's the foundation of where this comes from. Just a couple of points on this. So we are in favor of the proposed amendment from the Health and Welfare Committee. We think rightly put back in this plain vanilla private right of action that we see in the consumer protection all over the place and have for almost 60 years. It is not like the private right of action that's in Illinois. Illinois was the very first state in the country to establish a Biometric Information Privacy Act. It includes what's called statutory damages. So recall my boiler instance. I have to show my receipt that says it was $5,000. It's not like that. Instead, it says every violation is $1,000 under one scenario or $5,000 under another scenario. It just tells you the amount of money. And that's different than this. This is actually, you have to show your actual damages. So if you walk through the violation and what that might look like, to recover, you have to show your actual damages. In addition, this bill does something novel, which is it provides what's called a cure period. Those are extremely rare. I actually have never encountered one before. I'm sure they're out there. But what it says is, hey, if you violate this law, you have 60 days to cure the violation before a private right of action kicks in. So it offers this additional protection to businesses, not to the consumers, to the businesses, so that a private right of action is really being asserted against a company who has not cured in 60 days. So wanted to flag that. In addition, small businesses have been carved out. The smallest businesses have been carved out. The number has changed a few times, but I think that it's, people who have, companies who have 25,000 consumers, and someone can correct me in the room if I'm wrong about that, but I think it's 25,000 consumers in their database are not, this law doesn't apply to them. So the smallest businesses are not included in the coverage of this. Just looking through, does anyone have any questions so far about the private right of action? So there has been mentioned that Illinois has a bill that would take a second look at their private right of action. You should know that there are other states who don't have a private action who are also taking steps to try to revisit their own lack of a private right of action, because enforcers of the law have found that they want a private right of action. So I think that kind of runs both ways. Every state just needs to figure out what's best for their state. So Vermont needs to figure out what's right for our state. You should know that the Senate Economic Development Committee and the House Economic Development Committee in the 2020 session asked our office to form a working group to look at the issue of the Biometric Information Privacy Act, also data minimization and any other things that came up. We commenced that, and because of the pandemic, we really got into it in 2021 because we wanted to have it be in person. So we had 3 public hearings. People submitted written comments about their views on this. We compiled all of that into one place. We wrote a report with a recommendation. The recommendation that was made became eventually H121. And so this actually did come from a working group. Some of the people who attended are in this room right now. And it's all on YouTube. So I'd be happy to share, if you're curious, all the information from that process. And so we have looked at this. Regarding the period tracking app, you are absolutely correct. They, of course, if they violated the law, they would be subject to a private right of action if they failed to cure within 60 days and they met the threshold of the 25,000 customers. In Illinois, I wanted to note that big tech is several times has been sued using their private right of action. The largest that I know of is Facebook was sued, and there was a $650 million settlement. That was the outcome of that lawsuit. I'm not surprised that they are not a fan of the private right of action, obviously. I think there was maybe 1 million people were involved in that lawsuit because obviously Facebook is so incredibly popular. And you probably remember a time when Facebook used to do like face mapping and things like that, and they stopped doing that. They also, in Illinois, there was a settlement with the ACLU and Clearview AI. So there's definitely a lot of activity involving big tech companies. In TikTok, I think there's just recently a lawsuit taking place there against them. So regarding concern for like a run on the courts, I did mention that so far with our private right of action, the Consumer Protection Act, in the last 60 years, we haven't seen that. I also wanted to note that in the House Judiciary, I think Judge Zone did testify to this, and the comment that he said, he didn't seem concerned, but and you can go back and look at it for yourself, but the comment that struck me is he said, I would be, concerned if there were so many businesses violating the law that it created a run. It sort of, there's more questions that kind of come up if that scenario is really happening. I agree that we have not heard some of the voices in this conversation. We haven't heard, for example, from the individuals who may have used the private right of action to bring their own lawsuit. We have, I know that I remember the Equifax breach, half of Vermonters were caught up in that breach. And there's a librarian who was really activated by that, and she wanted to testify, but no one ever got back to her in the Senate. So I know that there wasn't interest, but things happen, it gets busy. And then the other thing I wanted to note was the data. So just getting back to this is a classic moment for education on the private right of action. The data broker registry is a notice act. So if you are looking to design a law and it's notice or registration with the Secretary of State's office, it's not the same as someone taking your personal face and doing something with it, right? You fail to register. That sort of is more of an attorney general job. But with regards to the actual bill, there is a cross-reference to 2453. 2453 is where when a cross-reference is made to section 2453, that's saying the Consumer Protection Act applies. So 2453 is basically the broad authority of the Consumer Protection Act. That includes, our steps in issuing a civil investigative demand. It includes, the enforcement, all the enforcement mechanisms. It's lots of different, invokes lots of different sections from the Consumer Protection Act. So I wanted to point that out to you. It's also important to know, with regards to the private right of action, the Attorney General does not represent people. The Attorney General is not permitted to represent individuals. We represent the state. So when we are enforcing the Consumer Protection Act, of course we're helping consumers, but we're mostly helping the marketplace and our system here in Vermont. Individuals should be able to represent themselves. And if someone violates their privacy, they should be able to take action themselves. I also want to note, you can't statutorily do away with class action lawsuits because that would be preempted by federal statute. I'm going to turn to my colleague to see if I forgot anything that I should mention. No, so I'm happy to answer questions.
Is there somewhere in this that prohibits class action lawsuits?
Well, there was reference being made to a bill in Illinois that would do that.
Oh.
But there's nothing in the health and welfare.
No.
Okay.
No.
That was informative. Thank you.
Yeah.
Senator Sears, I think you're muted.
Yeah, we're running up to our 9:45 timeline, and I appreciate the Attorney General's comments as always, but I still maintain, given the information, we're better off to get a report back and get it right next year. And I feel like the Judiciary Committee has been completely overlooked by health and welfare in adding these sections. So while members of the committee may not agree with me, you're certainly welcome to vote whatever way you like on the floor. But I will be voting against this amendment, and if it stays in the bill, I'll be voting against the bill.
Can I say just a couple of other things? I think it's important to take it in the context of the exemptions that already came over to us from the House that were important to, everyone in this context, including the House that passed the PRA. Publicly available data is exempt from the Act, and so so is law enforcement investigation. So generally, Clearview AI has images that are publicly available of folks, and they are using it in to help the FBI, et cetera. People know how I usually feel about policing, but it's actually far, far more accurate than other investigation tools, and was one of the tools used to find people involved in the insurrection in Washington, and bring them to justice. So Clearview AI has essentially national security and international security work that they do. I would also note that there is no ongoing case with the Attorney General's office and Clearview AI because the Attorney General's office failed to appear in court several weeks ago, and Judge Helen Tour dismissed the case. So,
Can I make a correction to a misstatement of fact, please? That is not true. What
Okay, so I think maybe instead of going back and forth,
yeah.
Senator Sears, what's your pleasure? Do you want us to continue this conversation, or would you like us to?
Well, it's
adjourn
up to you, but I have to get ready to get on Zoom for the floor, which I
Okay,
have to do
so-
5 minutes before. So I'm going to sign off and allow the committee to make
Okay.
individual decisions, or Senator, if you want to have a vote of the committee, we can do that too.
Would you like to respond briefly, and then I think we need to adjourn because we'll have to.
Absolutely. The Clearview case that we brought in March of 2020 was filed in Chittenden County, and the court said that she didn't think that was the right county, and we can refile in Washington County. We could also refile in Chittenden County if we do a few things. So it was not dismissed because no one appeared in court. That's not how it worked.
Thank you. All right.